Hello. Hello, can everyone hear me?
Sorry. Yes, sir. I can hear you. Can hear you, sir.
Hello, can you all hear me?
Yes, sir. We can hear you, sir. We can hear you, sir.
Okay, I want to assume that you can hear me. Sorry about the echo in the background. We'll go ahead and start the class right now. Welcome to the Gypsy Mentorship and Internship Program. A special welcome to the patent drafting class. This is week one of the first and second quarter of 2025. I want to specially welcome both mentees and mentors to this session. We will be starting right about now. Right, we'll be starting right about now, and we'll be commencing by reading our mentors profile. That's the mentors we'll be having in today's session. We expect to have two mentors in today's class. One of them being Mr. Rakesh Sharma. I can see Mr. Rakesh note taker is already on the call. So I'm expecting him to be here or to join us shortly. So Mr. Rakesh is having a thorough and multifaceted career, spanning nearly a decade in patent analytics, drafting and prosecution for US and EP jurisdictions. He worked very closely with various engineering teams and supported their portfolios and idea incubation to innovation management. Mr. Rakesh has excellent understanding of patent law, claim interpretation, and drafting skills. As a seasoned professional, he's readily engaged in various end-to-end IP services at different levels and provides intelligent IP solutions. He emphasizes more on promoting innovation for a better world. He loves drafting patent claims, keeping all the infringement perspectives in mind. Furthermore, he has a strong bent of mind towards IP automation and has sound knowledge on various IP tools and techniques that can be used to either improve quality of IP or increase the overall productivity. He is also an excellent mentor and possesses all the leadership qualities required for a successful IP profession. Um, Thank you so much, Mr. Rakesh. I hope that you join us shortly. Thank you so much, sir, for volunteering to, come mentor us on the patent class. Secondly, our second mentor that we're expecting in today's class, okay, I can see she's already with us, is Miss Amusa Shukurat Modupeola. Ms. Shukurat is a seasoned intellectual property consultant, analyst, and educator with public sector experience. She holds a master's degree in intellectual property from the prestigious African University Zimbabwe, in collaboration with WIPO and the Japan government. Shukurat is an alumni of the World Intellectual Property Organization, a member of the WIPO International Network for IP Educators, as well as a training facilitator at the NEST Innovation Hub. She was a member of the planning committee for the JIIPCC Committee 2023 2023 and resource persons at National Intellectual Property Conference NI, NIPC. Shukurat is an accredited agent at the Intellectual Property Office in Nigeria and the pioneer of the Intangible Nuggets, an educational platform which is responsible for fostering, among other things, intellectual property advocacy, awareness, and education. Thank you so much, Ms. Amosa Shukurat, for joining us. We are happy to have you in today's class. We'll go ahead and kickstart. Sorry, we'll go ahead and kickstart the session right about now. Seeing that we only have Ms. Amosa on call right now, we'll be taking an introduction from her on the topic for today. And then hopefully when Mr. Rakesh joins, we will also be having an introduction from him on the topic for today. Ms. Amusa, the floor is yours. We would like to kindly hear from you. Give us a run through the introduction for today's topic. You're welcome, ma. Ms. Shukrat, can you hear us, ma?
Hello, Dennis. Can you hear me? Hello.
Yes, yes, ma, we can hear you.
You can hear me, right?
Yes, ma, we can hear you.
Okay.
Sorry about that.
That's fine. Do we confirm that Rakesh should be available?
Yes, he should be available. His note taker is already in class, so I expect that he'll be joining us shortly.
Okay, that's fine. So good afternoon, everyone. On today's session, we'll be looking at patent drafting. Basically, this webinar is supposed to be patent drafting. However, we'll be looking at all the aspects of patent right up to patent drafting. So every week we'll be taking each session. I think for today, we'll be looking at patent basically. I've seen the presentation and I expected to see more of patent introduction than patent drafting introduction. Though the course itself is called patent drafting, but before you can understand what patent drafting is, you must have a very good understanding of what patent is. So we'll be starting with patent. And yeah, I think we will let the student take their presentation, the mentees take their presentation, then I'll be able to continue from wherever they stop.
All right, thank you very much, Ma. We're able to confirm from Mr. Rakesh, and he may not be able to join us today. But with what Ms. Shukrat has said, what we'll just do firstly is we'll take presentations from the mentees. So please, if the group presenter is on call, please, we'd like you to kindly share your slides or share your screen and then start your presentation. Do we have the group presenter in class?
Yes, sir. I'm here. I'll just a minute. I'll join briefly. Yes, sir. Good afternoon, everybody. 7 minutes. Okay. Sorry. Sorry, I'm trying to use my phone to share the screen. My laptop is not fixing that. I'm sorry for the time. I'm connecting with my phone. My laptop is not
Recording in progress.
Thank you, sir.
Please, can you go ahead and start the presentation? Let's find a way to, I think it may take a while, but I'll try and see if I can share your slides from my end. But can you please go ahead and start your presentation so that we don't really waste time. Hello, Ifunaya, are you with us? Hello, Ifunaya, are you with us?
Yes, I'm with you.
All right, please. I said you can go ahead and start your presentation. I'll try from my end to share your slides. It may take a little while, but I'll see what it is.
Okay, yes, let me go ahead with the presentation. Good evening. The voice is echoing.
It's echoing in the background.
Good evening, everybody.
Good evening, everybody. Good evening, everybody.
It's still echoing.
It's still echoing.
Maybe you should log out with the other device you are not currently using.
Okay. Is it better now? Hello, good
Yes.
evening, everybody. Okay.
Good evening.
Thank you, sir. So today, I'm Ifnaya Promises Ebalum. I'm an intern from the pattern drafting. I'll be representing my teammates with the topic, discussing on the topic Introduction to Pattern Drafting. Our course title is Pattern Drafting, and today we will be discussing the introduction, what beginners must know, pattern subject matter, and why is patent important. So going to the introduction, basically knowing what patent drafting is. Patent drafting tells us how a patent application is prepared, the procedure, and it involves giving a detailed description of the invention, the discovery itself, the claim, and where drawings are necessary, giving a description of such as well. And patent drafting is geared towards preserving the rights of the inventor, the person who brought the invention or the discovery, giving that person an exclusive right, to owning that invention or discovery or process, that new process, as opposed to any other person. And this is done with the guide of the legal provisions, the laws or legal authorities establishing such. Moving further, patent drafting is governed in Nigeria by the Patent and Design Act 1971. It provides for the basic drafting and filing patents. So it guides us on the procedure on how to go about drafting applications. And it's also important that we note that a patent expires, the duration is just 20 years. That's the duration for its validity. Sorry, my phone is hanging. Let's wait, help me. Sorry, a minute, my phone is hanging. I closed the document to open it again. Okay. Sorry, it's opening. I closed it to open again because it wasn't responding.
Okay, your screen is being shared, so please, you can just go ahead. Thank you so much, Mr. Akinwale. I'm having issues from my end sharing the documents. So.
Okay, I can speak from the Zoom app. Okay, thank you. Thank you very much. So going to the key elements of patent drafting, the things that we need to know, that's the basic features. When you're talking of drafting a patent, what are the basic things that needs to be there? So in patent drafting, the procedure is first to get the applicant's full name, the name of the inventor, the full name, the address, and if that person's address, like the person is resident outside the country, the person needs to provide an address within jurisdiction, that's within Nigeria, if the person's address is outside Nigeria. Again, the person needs to give a detailed and relevant description of that invention made or the new process made. Also the claim and any other relevant information as provided in Section 3, Sub 1A of the Patent and Design Act. Let's come. Hey, trying to go back to seeing this slide. It's showing me. It's showing me. I can't see the slide again.
Oh, okay. It's showing your. I think it's from your end.
It's
Why
showing
don't
me.
you?
It's showing me the faces like instead of the. Okay, I've seen it.
Okay, please carry on.
Okay, thank you. Yes, thank you. Again, we were talking about the key features that we need to know while drafting a patent. It's also accompanied with the prescribed fees, the amounts to be paid, and the inventor needs to make a declaration, like something, will I say is like an affidavit, something affirming that the true inventor wants his or her name to be mentioned, recognized in that patent, and the person will be given his full name and full address. And if the application where it is made in the place of an agent, that's not the person himself, not the inventor himself, but through an agent, then there will be a need for a power of attorney showing that I have given this person the power to do this on my behalf. That's it. Then this guy see the next slide. Okay, thank you. Then patent as a subject matter. The core thing that we need to know, or the hallmark of patent itself, is that it is new. It's something that refers to a novelty, a new invention, a new discovery. If it's not new, then it's not eligible to be a patent. So that's it. All things invented and discovered cannot just be patentable. The key thing there is that novelty. It's new. It results from an inventive activity or is capable of industrial application. Like when you check pharmaceutical industries, when they try to produce drugs, it's through all these inventions that they're able to know, okay, this is the right drug for this is what is applicable. So that novelty is what makes it patentable. And then it's also constitutes an improvement. When you talk about patents, there is an improvement on what has been invented upon. That's another thing that makes it patentable. So either it is new in its entirety, or it is a new process brought in, or it is an improved invention of what has been. So these are the things that make it patentable. And the examples we have here, we have books, medicine, like I referred to some pharmaceutical industries, and the formula for a soft drink, and shape of phone. Shape of phone, we can even refer to the Apple. When Steve Jobs and his team invented Apple, it was something different. So we have Apple phones and the rest. Then we talk about why patent is important, why is it necessary? Like we said, the novelty is that it brings something new. And in this newness, it helps to protect the rights of that inventor. So there's an exclusive right given to the inventor, and it helps people to keep bringing more invention. Then another reason or importance is there's improved innovation. So what has been doesn't just keep trending. There's gap to improve upon that which has been. So that's another thing. It encourages innovation. So people's minds are more creative. They go on and on to find more solution of things that has not been. It promotes market advantage, boosts economic growth. Like in the nation or in the world at large, it helps there's more room for improving the economic state of the country, protect intellectual property, people's ideas and the things they come about are being protected. There's no copyrights or things like that. And it also enables licensing and revenue. The money generated from it is licensed legally and then it generates money. And it also attracts investors, more people come in to invest. So conclusively, we say that patent drafting is a crucial step in securing legal protection. So why there's laws that protect this patent drafting is to help safeguard the people's and inventors' rights instead, and inventors' right and intellect. So it's given only to the person that has invented such new method or whatever new thing that has been invented or discovery or procedure. So that is the essence of patent drafting. And then we have questions as well. There were questions that were cropped up. One of those questions are what are the grounds for refusing patents? We already said that there must be newness, but what are other grounds where things can be patentable? The second question we have is if there's a dispute arising from patent, which court will have the jurisdiction to entertain such matter? Then since we said it's 20 years validity, if it expires, is there any room to re-register such patents? And if there is room or rights to re-register, what's the duration of years? So these are our questions from the group discussion. Thank you very much for the privilege to do this. I hope you're able to understand. Thank you.
All right. Thank you so much, Infunaya, for that presentation. Well done to you, also to your team for putting together the presentation. And thank you, Mr. Akinwale, for helping us share slides. So thank you so much. Now we want to go over to Ms. Shukurat. I'm sure she had the presentation and everything Ifunaya said. So please, ma, I would like for you to give feedback to the presentation and also what you would like to have or what you have for us today as a discourse on the subjects or the topic for today.
Hi, Dennis. Can you confirm you can hear me?
Yes, ma, I can hear you. Mr. Akinwale, please, you can stop sharing your screen.
The network was breaking at a point, so I'm not sure I got the full presentation. However, I listened in, and I'm just going to give in few comments. First of the presentation, like you are meant to speak the presentation, right? So when you are doing your presentation, try as much as possible to understand the aspect of whatever it is you're trying to explain, so you don't get it all complicated or so to start with, yes, you can start with the Patent Act, but if you don't understand what patent actually is, there's possibility you might not also understand what the act is. So let's look at what is patent. Patent is actually an exclusive right given to an inventor that's come up with something that is new, inventive, and industrially applicable. And like you rightly said, there are criteria for which you can get patents. If your work is not new, that is novel, it is not inventive, and if it is not industrially applicable, you can't get patents for it. Also, you spoke on the patentability subject. Yes, there are subject matter. Patent protection is territorial in nature, such that whatever you protect in a jurisdiction stays. And so the patentability subject matter varies from jurisdiction to jurisdiction. What might be patentable in Nigeria might not be patentable in other jurisdictions. So you have to understand what the law says. And this is where the Patent Act comes in to enable you to understand what is applicable in Nigeria. What does the law say? What can be patented? What cannot be patented? As opposed to what we have in the general Paris Convention or the TRIPS Agreement. So when it comes to patents, it's just like a trade by barter between the inventor and the government, saying that, oh, I've come up with an invention that I believe it has public value and it can help us in this in Nigeria, for example. And I want the government to give me a protection for this invention. And the government says, okay, yes, why not? We can do that as long as you give us a full disclosure of whatever it is you have done, such that once this patent expires, somebody else is able to pick up this invention, use it without infringing on your right. And so the patent protection period is usually 20 years. Though in some instances, it might exceed to 25 years, especially the pharmaceutical industry, because in some cases, when it comes to pharmaceutical industry, it takes time before they do their testing, before it gets to the market. And you realize that by the time the patent has been granted, it's just they only have few years left to actually benefit from the patent. So in instances like this, there are exceptions and limitations so that the patent can be moved, like the protection period can be moved to maybe 25 years. But like I said, it's basically with pharmaceuticals and not other industries. So yes, when it comes to patents, you want to have that protection period, and you want to make sure that patent is new, industrially applicable, and inventive. With patent also, it's not only about inventor. We have to look at balancing both the public rights and the private rights of the individual. So if an inventor should patent something, and imagine the government giving the person about 50 to 60 years protection period, that's going to hinder innovation in the society. And so that's why the protection period for patents is limited to 20 years. And once that 20 years expires, what happens? The patent goes to the public domain, and everybody can decide to pick that patent up and probably rework on it, come up with something to upgrade it, then probably file a claim application for that invention as well. As long as it is new, it is industrially applicable, and it is inventive. So these are the basic steps when it comes to patent. So what can be patented? Basically, you can patent a product or a process, and you can also patent a product by process kind of invention. That the invention has both process and it has both products, both process and product. So things like this can be patented. Now, what cannot be patented? You can't patent things that occur naturally in nature. So, for example, you want to patent how to six oxygen from the air. That means if you are doing something like that, you are going to be putting people's life in danger, right? So why should the government give you a patent protection for something like that? So although in other countries it's possible, there are countries that have patents on suicide machine, right? But in Nigeria, we don't have something like that because we also have that patent not violating public morality. And public morality is subjective depending on how it is in that country. So what we might term violating public morality might not violate public morality in other jurisdictions. So like I said once again, we have to bring it down to Nigeria and see how it applies in our patent acts. See how we have to exploit the patent or maybe grant the patent or not grant it. So if you have questions, let's ask questions.
All right. Thank you very much, Ma. I think there were some questions that they asked while they presented. So let me see if I can get them and share them with the group. Yeah, and please, if it's possible, can we also try to ask questions? If we have like questions, please, you can indicate by show of hand, right? And we'll get to take your questions. Do we have anyone with a question? If you have anyone with a question, please, you can also send your questions into the chat box so that we can pick it up from there. Okay. Okay, Beatrice, you say you do. Okay, please, you can go ahead, unmute yourself and ask your question. Okay. So Beatrice is asking, what are the processes of registering a patent?
The process for registering a patent. Well, the basic thing, can you hear me?
Yes, ma'am, we can hear you.
Okay, so the first thing we want to look at is the criteria for patentability. Is your patent new? Is it inventive? Is it industrially applicable? If your patent doesn't have these three things, then you can't actually file a patent. Also, you want to look at the patentable subject matter. because when you are filing a patent application, it has to have a title, and that title must fall under that category of patented subject. So if the title is not something that can be patented, then you can't file a patent. If the patent application or the invention is not, you can't get a patent for it. If it's not initially applicable, you can't get a patent. If it's not inventive, you can't get it. So all of these things have to be present: patentable subject matter, inventiveness, novelty, and industrial applicability. It has to be present before you are able to file a patent application. So when filing a patent application, the agent, or the body responsible for patents in Nigeria, the Patent and Design Registry. So you have to file through the Patent and Design Registry. Although there is an online platform where you can file your application, however, you have to have someone in the office to probably follow up on the application to make sure that your application is accepted. So during application, if maybe your patent application doesn't meet up with some particular formality, let's say you don't have your abstract, you don't have your title, or application is not well drafted, probably going to get a rejection, or they send it back to you to say you can probably work on this more and that get rejected. Work on it, you can now resubmit it again, making sure that everything they asked you has been done. Because in Nigeria, we only examine patents as to formality and not substantive. So they are really not going to check if you have your application is new, like novel, by comparing it with other prior acts to see that it's actually new. So the basic thing you have to make sure you're doing is that the formality, your name, your invention, placement of the application, they are well done. You are paying. So that's the formality that your application won't be examined as substantively. So if peradventure someone comes up and say, oh, this person has patent, or this person's patent is similar, or this person's invention is similar to what I have done, it is at that point you now decide to probably go to court, and you're going to analyze and see if truly there is a reason for that patent because it's similar to what already exists. It's already prior act. So you cannot decide to pick it up from there. But while filing initially, your application will not be examined. How that answer the question?
Okay, sorry, Ma, I was struggling to hear you towards the end. I want to confirm if it's only me that was having that struggle, or it was a general problem. Mentees, did we hear everything Ms. Shukra said in response to the question?
Yes, sir. I heard quite well.
Okay.
I did.
All right, thank you. So I want to read the questions that they sent while they made the presentation. And the first one here is, what are the grounds for refusal of patents? What are the grounds for refusal of patents?
Can you come again? Can you hear me?
Yes, ma'am, I can hear you. Yes,
Okay.
ma'am. The question is, what are the grounds for the refusal of the patents?
The grounds for refusal of patent, is that what you're asking?
Yes, ma'am.
Okay. So before a patent can be refused, then the grounds could be maybe because it's not novel, that is, it's already existing, it's similar to a prior act. If your patent is not novel, then that could be a ground for refusal. If your patent is not meeting up with the criteria, like the formality now, based on formality for those countries that examine as to formality, your patent application could be rejected. Now, for countries that examine as to substantiveness, novelty, industrial applicability, novelty and inventiveness, basically, they are very important for countries that examine as to substantiveness. So in Nigeria, we examine as to formality. If someone decides to come and say, and raise an opposition during the patent application and says this patent is not new or it's already existing, then it can actually be refused and they won't grant you a patent application, a patent certificate at the end of the day. So these are basically the grounds for refusal.
All right, thank you so much for answering that question. The next question here is, if there is a dispute arising from patents, which court has the jurisdiction to hear it?
The intellectual property basically is territorial in nature. And so I guess it's the federal court that is situations on IP generally. It's federal, not states, because it's territorial in nature, the federal government, the federal courts rather.
All right, thank you so much. The third question is, after expiration of the patent, is there a right to re-register? Is there a right to register the patent after it has expired?
Once your patent expires, that's it. The only thing you have to do before it expires is that you have to pay a maintenance fee yearly. Like every year, you pay a maintenance fee to maintain your patent. And once it expires after 20 years, it expires and goes to the public domain. There's nothing you can do about it. But if you don't pay your maintenance fee, your patent can also expire before that 20 years if you don't pay your maintenance fee. So your maintenance fee is what keeps your patent like alive. What keeps it breathing for that 20 years. So after 20 years, it goes to the public domain and anybody can pick it and use it. But what you can do is probably improve on that invention, then file another patent. Then you get another 20 years and you keep doing that till you are tired.
All right. Okay, thank you very much, Ma. Simi is asking here is, can patents be extended?
If patent can be extended, right?
Yes.
I think I mentioned that earlier, but like I said, is specifically for pharmaceutical patents, because before a pharmaceutical patent can be granted, it goes through a lot of processes. And by the time the patent is being granted, they still have to do so many clinical trials and all. So while they're doing the clinical trial, the patent application is already written. By the time they finish that, maybe they only have few years left. So they probably give them like a 5 years extension period. I think it's 5 years is the highest, 5, but it's limited to pharmaceutical patents.
All right. Thank you so much, Ma. So please, do we have any other questions from the mentees? Do we have any other questions that our mentees would like to ask in regards to today's topic? Basically, what we are doing today is an introduction. Okay. Beauty is asking, please, how long does patent application take? How long does a patent application take?
How long does a
Patent application, how long does it take to apply for?
well, let's say between 6 to 12 months.
Okay. All right. Okay, so do we still have any other question? Because so far, like I said, what we have today is basically an introduction, right? And in the introduction, we're just giving the highlights. Sorry about the echo. We're just giving a highlight to the topic of the day.
Dennis, are you there? I'm not sure I can hear you. Dennis, can you hear me? Can you hear me, Dennis?
I think he's locked out. Maybe he's having issues with his network or so.
Okay. Is Sophia here? Sophia? I think there are some questions. Can one use or sue in patent while applying for patent? You can only sue once you have a right established. When your right has not been established, that you haven't been granted patent, then you can't sue. You can only sue the moment your right you've been granted a patent right. You can't sue while filing, because what will be the essence of suing? What exactly are you suing for? You are suing for something that you're not even sure if you're going to get a grant or not. So you can only sue after you've been granted a patent right. And the next question says, can an invention be patented in multiple countries? Yes, it can. So basically, there are different filing routes. We call them filing routes. We have the national filing route, the regional filing route, and the international filing route. I think we'll be talking about that probably in the next 2 or 3 classes. So what you do is, if you want to file in a particular jurisdiction, because IP right is territorial in nature, you get someone in that jurisdiction, like an attorney, to file your patent application for you. So say you want to file in Nigeria, you want to file in Ghana, and you want to file in maybe Australia. You get an IP consultant or IP attorney in Nigeria, IP attorney in Ghana, IP attorney in Australia to file for you individually, so in each countries. However, if you don't want to go through that route, you can go through the regional route. The regional route is such that you are filing regionally. Let's say you want to file an application in African countries. There is a body that covers both French-speaking African countries and English-speaking African countries. That's ARIPO and OAPI. However, Nigeria and some other um, countries are not member states to that regional body. And so we cannot file because we are not member states. But member states or countries who are member states to that regional filing route, they can file. And what they're going to do is they're going to designate other member states who are also members of that regional filing route. So in ARIPO, we have about 27 member countries. So what that means is that we have Ghana, we have Kenya, we have Togo, and so on. I'm not sure Togo is part of it. So you can file in that using that regional route, designating those countries you like to file in. So while we have regional routes, we also have international route. International route is what we call the PCT, the Patent Cooperation Treaty. So if you want to file internationally, you can decide to select as many countries you want as possible to get your application protected in. So if you want to file maybe just one application in 2 different countries, it might not be advisable for you to go through the international route because it might be cost effective. It might be more expensive compared to you just going to maybe Nigeria and maybe Ghana to just file individually. So it also depends on the countries, the number of countries you are trying to cover, and also where you have a market. It's not also advisable for you to file application in a country that you don't even have market for that particular invention. The next question says, does the 20 years duration for patent subsist only when the idea hasn't been invented? Does it cease once the idea has been invented? So invention is when you bring an idea in your head, you bring it to life, like you've invented. That's invention. So it only applies after you filed a patent application. So you might not even have the product itself. You might have a pilot product, like a pilot plan that you just used in testing while you were writing your application. You can have something like that. But your 20 years protection starts from your filing date. The moment you file a patent application, your 20 years duration starts counting. And once it's 20 years, your invention goes to the public domain. So it doesn't start counting when you have the idea in your head. It starts counting the moment you file that application. And it is not a necessity or compulsory that you submit an end product at the end of the day. You don't have to submit an end product, but I'm sure that while you are trying to get a hang of what you are doing, you must have done some test run, some pilot plans or some pilot projects to arrive at your final answer, because in your application, you have to disclose everything, what you did to get the final invention. So that disclosure is very important. What patent route does Microsoft Patent use? I don't understand what you mean by Microsoft Patent. So Microsoft Patent may mean patent owned by Microsoft. Is that what you mean? Kindly clarify, Simi Ajayi. If a particular invention is patented by two individuals claiming to be the rightful owners of the same invention and they file it at the same day, but they got the patent right at different day, does first in time rule be applied? So Nigeria is a country that we grant patents, or we grant IP right, basically based on first to file. So we are a first to file, we operate a first to file kind of system as opposed to a first to use kind of system. Now, when it comes to patent, there's something called the true inventor and the statutory inventor. The true inventor, that's the person that invented, or the person that brought the invention to life, the person that invented the invention. In most cases, is not always the statutory inventor. The statutory inventor is the person that filed the application. So even if you invent something and you don't go ahead to file it first, the person that filed it first will be known as the statutory inventor, and you that probably worked on it might just be the true inventor, but it's the person that files it that owns rights to the patent or to the application at the end of the day. So if you are an inventor, it would be nice for, let's say you are working for an institution and your job description says you are an inventor and you have to invent so. Your name as the inventor has to be written boldly on the patent application. But when it comes to ownership of the application, it's going to belong to your organization or your employers, not you. You are going to be the true inventor, while your employers, who are going to be the one filing the application, will be the statutory inventor. Now, for some other jurisdiction, their law might differ from what our own law says. Some other jurisdiction might give the inventor, who is the true inventor, the right to file the application, and on the long run, they will have to transfer their rights to their employees or their employer, who is now the statutory inventor. So different law applies for different jurisdiction. You need to understand what works in the jurisdiction that we are in. Please, how can one know that its patent application and secrets is being protected? So patent and trade secrets are two different things, right? When it comes to patent application, there's a requirement that you have to disclose everything you are doing. But when it comes to trade secrets, it means you have to keep that information confidential without disclosing. So it's left to you to decide as, let's say, an entrepreneur, which one best suits what you are doing. Are you working in a fast moving industry? Do you think what you are doing just need few years of protection, or do you think it needs longer years of protection? See, for example, Coca-Cola is a very good example of a company that has been relying on trade secrets for more than 100 years. Coca-Cola, they decided not to file a patent application for their recipe. If Coca-Cola had filed a patent application for their recipe, what it means is that 20 years from the date they filed that application, they would have, their patent would have been a public domain by now, and everybody will come and say, oh, I can make Coca-Cola because they filed a patent, and since their patent had expired, their everything about their patent is in the public domain and they can use it. However, Coca-Cola opted for trade secrets, such that they are in a better position to protect and keep this recipe confidential by making it available to only few people, and these people are well, like their family is well taken care of, and the secret itself is well guarded. Not just one person can access it without the um, influence of others. So it's been said that the people that guard Coca-Cola's trade secrets, they are not in the same place at the same time, so as to avoid stories that hurt. Then the next question is, what patent route does Microsoft patents use? For this question, I was asking about the patent Microsoft owned by Windows. So when it comes to Microsoft, especially computer programs and software, on its own, they are classified under copyright because they deal basically with numbers, zeros and one, and 0 and 1 are classified as literary works. So if you have a computer program that you've developed, and this computer program doesn't have inventiveness is the real deal, it doesn't have technical effect, then you can't get a patent application for that. On the other hand, take for example the Apple wristwatch that can read blood oxygen. That kind of watch, it has an application that works with it, but on the other hand, it can read your blood oxygen, it's doing something. So that kind of application has both copyright protection for the application, the software application, and patent protection for the watch itself, because the watch has a technical effect. So in a case whereby your should I say computer software doesn't have technical effect, you are likely not to get a patent for it. Again, it depends on the law of every jurisdiction. There are some jurisdictions that grant patents to computer programs, but in Nigeria, your computer programs, your software programs are basically protected by copyright. So looking at that of Microsoft could have different patents on different aspects of whatever it is they've done. So it is called a Microsoft patent because that now Microsoft is like a trademark now. Not if you are going to search for if you want to do a patent search on the patent owned by Windows, if you put in Microsoft, it might not come out because at the point why they were filing that patent application, they probably haven't even named the brand yet. So you are likely not to get a result using their trademark to find it. So it could be a patent application that says maybe a way of doing this and that, or a product or a process of doing this and that. So you might not find a Microsoft exactly as the patent. So yes, each companies have different patents. Just like if you're looking at phones, there are different patent application that makes up a phone. And each of these patents are owned by some organization who are the statutory inventors. Meanwhile, the inventors who actually work on it are the true inventors. I hope that answers the question. Okay, one last question. What patent route does Microsoft Patents use? So it depends. It depends on your IP strategy. Where do you want to cover? Which jurisdiction do you think will buy your product more? Or which jurisdiction jurisdiction does your product appeals to more? So it depends. If you are looking at, oh, I am just looking at an African kind of invention, then it will appeal more to Africans. And doing so, you might want to go through the route of regional patent application, which is either ARIPO or OAPI. OAPI is for the French-speaking countries. So if you select OAPI, then it means your patent will be filed across all the 17 countries who are member states of OAPI. If you select ARIPO, then you designate, if you don't want your application to be filed in all those ARIPO countries, you designate which of the countries you want your application to be filed in. So it's not a straightforward answer. You can't just say Microsoft has international patents. It's possible they might have international as well, but they might probably have designated countries they want it to be filed in. So if you want to file in much countries, if you want to go the international route, under the international route, you can decide to click on ARIPO, designate ARIPO, designate OAPI, designate EU, and other countries who are members of the Patent Cooperation Treaty. I hope that answers the question.
All right, thank you so much, Ma, for helping us with the questions. Sorry, my network logged me out on all my devices, so I'm so sorry about that. Once again, thank you so much, Ms. Shukurat, for taking over and helping us run through the questions. Just before we go for today, we would like to take a quick screenshot. We normally do this to keep record of the class and just to notify that you attended class, and also for our social media posting. So please, I would like to ask mentees that are currently here on call, please, can you kindly turn on your videos so that we can take a quick screenshot and we can call it a day. Thank you so much, Ms. Shukurat. All right, thank you, Simi. Thank you, Mr. Akinwale. Can we have more mentees? I can see Beatrice Ifunaya. Thank you so much. All right. Okay, that's fine. So I can say we've come to the end of today's class. Like I said, this was our opening session. It was introduction into patents. And thanks to Ms. Shukurat for doing a very good job on taking us through what basically patent is. I'm sure as we continue in subsequent classes, we'll get to have more in-depth, or we would get to go more in-depth into the matter of patent drafting. Well, I would want you to find out yourself. So thank you so much for being here. Thank you to Ms. Shukurat once again for being on class. Please kindly be reminded that class is 4 p.m. every Friday. 4 p.m. every Friday. So once it's 3 or 2 minutes to time, once it's 4, we'll kickstart the session. Please enjoy the rest of your evening and have a wonderful night rest. Bye-bye, everyone.
Thank you, Dennis. Bye.